I'm also surveillance video of drop boxes. And so that's how we've addressed our pleadings, our response, because that's how it was pled. I didn't hear any of that today.
Additionally, Ms. Meingast, they did say in the second paragraph that the named plaintiff was removed.
Right, but if you look, that's why their pleadings are confusing, because their pleadings talk about election inspectors of both parties not being present for various aspects of the counting board process. Mr. Ostergren is not an election inspector, he's a challenger. And so there is some, to me, we're at 6s and 7s with respect to what the pleadings are actually saying and what kind of is really going on or what the law is. And Mr. Ostergren doesn't explain where he was excluded from, which AV counting board, what day that happened, why he was excluded. And that doesn't even really feed into his exclusion for whatever reason, doesn't feed into the claims that they've pled, which for their arguments are that election inspectors from both parties are not always present at the counting boards to review the process. That's what their claim is, and that challengers are not having an opportunity to review surveillance video. So that's, I'm just going on what the pleadings say, Your Honor, is the source of their alleged injury. And it's not really kind of matching up with the argument that we're hearing from counsel this morning. And again, at this point, it's all really moot because the counting boards are complete. We've moved on to the sort of the second phase, and all of this, all of the unofficial results and all the poll books and all the ballots and all that will be moving on to the county canvas for the boards, the county boards to look at. So, you know, there isn't any relief that can be given at this time with respect to, you know, halting this process and allowing challengers more opportunity to review, or to fix some alleged irregularity and not having precinct inspectors or election inspectors of both parties present for these functions. So, you know, that's what we've principally responded in our response. They also lack standing. And then if you even get down into the merits of their claims, if you even got there, there really isn't anything to it because they don't have an opportunity. You know, there is no right to review the surveillance video, and there isn't really any kind of obligation, as we read the statute, that somehow, you know, an election inspector of both parties has to be present 100% of the time and 100% of the places at the absent voter counting board. So I just feel like there's a little bit of disconnect between what their pleadings actually state and some of the argument that we've heard today.
Okay. On behalf of the proposed intervener present, Amiki.
Good afternoon, Your Honor. Kevin Hamilton for the Democratic National Committee. And first, I'd like to thank Your Honor for the opportunity to appear, and I'll be brief. I believe the motion should be denied for several reasons. First, the plaintiffs have failed to establish an actual controversy under MCR 2.605, which would be necessary in order to pursue a claim, for the simple reason that the factual record before the court doesn't support the relief sought. And in any event, the claim is largely moot at this point for the reasons Ms. Meingast just pointed out, that the county counting boards are largely complete now, and so the relief is simply unavailable. On the first point, no evidence in the record would allow the court to conclude that the plaintiffs have demonstrated a likelihood of success on the merits, which, as Your Honor pointed out a moment ago, is a necessary finding in order to enter injunctive relief here. The affidavit obviously is hearsay, Your Honor, at least single hearsay, perhaps double hearsay. And that is simply insufficient under any standard to justify declaratory relief. Moreover, as we've outlined in our papers, and I know Your Honor hasn't had the chance to review those yet, they've sued the wrong defendant. The Secretary doesn't operate these counting boards. The counties do. They are created and operated by local government. Those local governments, the counties, were not named as defendants, nor could they have been before this court, whose jurisdiction is limited under MCL 600.6419. So that's obviously a problem with the relief sought. On the merits, as counsel just pointed out a moment ago, there's no right to video surveillance of voters casting ballots, whether they're casting them in person or at drop boxes. And counsel doesn't even really pretend otherwise. He cites no statute and no case law that suggests that a voter or a political party or candidate has a right to surveil or review video surveillance of voters casting ballots. And in any event, even if there were some sort of factual record, and there's not, that might support the court in finding some kind of violation of the challenger statute, Michigan law provides a remedy for that. It's a criminal penalty. The legislature thought about that. What the legislature did not provide is any sort of statutory authority for a court to conclude that some violation has occurred and therefore you should stop the count or enter some broad injunctive relief. That's just made up out of whole cloth. And again, plaintiffs don't identify any authority for that proposition at all. And that's not surprising. There just isn't any. There's a purity of elections clause claim and an equal protection claim. Neither of those find any support in the law. The Trump campaign has asserted similar equal protection claims elsewhere in the course of this campaign. They have been uniformly rejected. Trump versus Bakvar in Pennsylvania was a similar claim relating to restrictions on poll watchers and challengers. The court rejected it there for exactly the reasons that we're talking about here. The claim was based on, I'm quoting, based on a series of speculative events which falls short of the requirement to establish a concrete injury. I won't go through the other cases, Your Honor. They're cited in our brief and we quote from them at length. So for all those reasons, Your Honor, we think the motion should be denied. It's unsupported by the factual record before the court. The only evidence that's before you is both irrelevant to the actual claims in the motion and the pleadings, as Ms. Meingas points out, and hearsay, as Your Honor has already noted. The claims are unsupported by the law, and they name the wrong defendants. So all of this is simply an effort to stop the counting of ballots cast by Michigan voters who were fully entitled to vote and are fully entitled to have their ballots counted promptly and in accordance with Michigan law. So that there's no support for this motion, Your Honor. There's no support for this litigation. The motion should be denied and the lawsuit should be dismissed. Thank you, Your Honor.
Is there anything else you would wish to say, sir?
No, other than...
Oh, I'm sorry. I should have said on behalf of the petitioner.
Okay. Thank you, Your Honor.
On behalf of the petitioner, I did have a couple of questions. Now, it was, I think, last week, Mr. Grill, that we had a case that was filed against the Secretary of State regarding this, quote, meaningful access. Am I remembering correctly, Mr. Grill?
There was a case about challengers, Your Honor. There have been many cases.
But that one was resolved by the parties, and the question there was to have the Secretary of State revise her instructions to the local election officials regarding issues of COVID-19. And in that case, the question was, how could the qualified challengers have meaningful access to execute their functions? And the parties entered into an agreement, and a new directive was issued by the Secretary of State to the local elected officials regarding things like distancing, etc. That was a recognition, Mr. Hearn, that while the Secretary of State has a future function in this electoral process, other than giving directive and intervening in specific circumstances where extraordinary relief is requested and warranted, that the Secretary does not conduct local elections, nor does the Secretary's office have responsibility for the initial ballot tabulation. So, and I need some help from you on how the party against whom you have filed suit is a party who has the capacity to do what you've asked, even if it is warranted.
Thank you, Your Honor. Yes, no, the Secretary Benson is Michigan's chief election official, of course, and the local election jurisdictions act under her direction. She does have the responsibility to oversee the conduct of the election. In fact, there was the Western District of Michigan federal case where they did, in fact, name Secretary Benson, and then they named a number of local election jurisdictions. And in that case, the Secretary of State responded by saying that the local election jurisdiction should not have been named, but she should just be the sole defendant, and that's, in fact, what was done. And that's...
But
really,
what was the issue there?
well,
That was your issue about, and was that your, there have been so many, and for every court of claims case, there have been 2 federal cases, so I know why Mr. Grill and Ms. Meingast are a little confused. There was a case filed in the district regarding the mailing of absentee ballot applications. There was a case filed regarding the processing of absentee ballot application signatures, and a few others. So I don't know what that Western District case was about, but every case that I have had, it has been acknowledged, and it is my understanding of the law of the state of Michigan, that while she does provide supervision in the broader sense, and she does provide direction, that it is not she who would be saying at Precinct 5, District 6, you, Mr. Challenger, you, Ms. Challenger, may be 3 feet away, 2 feet away. You may approach the poll book and take it in your hands. You may not. So I'm trying to understand this direction for meaningful access. She has issued a directive for what was described as meaningful access, which enumerated the functions of challengers and poll watchers from the statute. She's issued that.
correct.
At best, what you gave me in paragraph, Mr. Osterman says that he was, in fact, a credentialized official, and he says he was ousted from a polling place, but he doesn't tell me where or when or any circumstances. Your affiant says that another person came to her at a specific place, at least, and told her that there was activity going on that was inappropriate. Your pleadings spoke in significant detail about what credentialized officials were supposed to do under the statute, and speaks with great particularity about the ability to observe certain videotapes.
That,
I'm in a quandary here.
okay. Your Honor, I will try to assist and clarify the extent that there's an issue. What we're asking, and let me talk about the videotapes and the ballot boxes, those are essentially equivalent to a polling place, and the statute that was adopted by the Michigan literally last month, provides for video surveillance of those ballot boxes. The reason for that is to provide transparency of the election process. So when those ballots are authenticated and counted, that there's an opportunity to observe that, observe the casting of the ballots in the ballot, these remote ballot boxes. That's the part of the complaint that asks to have challengers have access to those videotapes, the video surveillance.
So let me put a pin there. So when you were describing, quote, meaningful access, you wanted this court to order, ignore the fact that counting is done, but you wanted this court to order that each and every videotape be presented to or be available for challengers prior to the counting of the ballots?
That would be the request that we have, that the challengers have the opportunity to review the videotape, which is in the possession. Let me be even more precise, Your Honor. Our request is that Secretary Benson issue a directive to the election jurisdictions, making that video available so that challengers can have some transparency and observe the casting of ballots in these remote ballot drop boxes.
Okay, so
Your Honor.
remote ballot drop boxes. So it's your contention that there was a requirement that for every drop box that there be a videotape made of that drop box. That's correct?
That's what the Michigan statute provides,
Okay.
Your Honor.
And the drop boxes were the drop boxes not placed prior to the passage of that statute?
The statute makes a distinction between drop boxes that were placed prior and drop boxes that were placed after October 1st. And so the statute requires the video surveillance of the ballot drop boxes, and that requirement becomes effective, and I would quote it to you, I just don't have it right in front of me right now. That is, I believe, October 1st and thereafter. And all we're asking is that a challenger be able to review that video for those ballots that are processed out of those video drop boxes. And then,
So just a question. As of this point, there's a drop box. Once the ballots are taken out of the drop box, are they segregated based upon which drop box they came from?
we have asked that there's other litigation by other parties that has asked that they be segregated so that you can identify what ballots came from what box, and you can tie that back to a video.
But are you saying there was a statutory requirement that they be segregated?
There's not a statutory requirement that they be segregated,
So,
but there is.
Are you alleging that there was a practice or routine where the individual local elected officials, election officials, separated the boxes based upon which drop box?
The request that we have of Secretary Benson.
That's not what I'm asking you. I'm asking you as a matter of fact, are you alleging that the individual election officials had a practice that segregated the ballots per ballot to ballot drop box?
I can't tell you, Your Honor, because there's so many election jurisdictions in Michigan, which ones did in fact do that or which ones didn't. And so I can't make a representation of the court as to what in fact each jurisdiction did do.
So we know that there were, that there were additional drop boxes added. I don't know if there were or not. And we do not know whether or not the contents of those drop boxes as of October 2nd were segregated from those contents that were there before October 1st. We just know that somehow those ballots were taken from their secure drop boxes to the local election official, and at some point were processed. That's pretty much all we know, right?
That is correct, Your Honor. I would add, though, we also know that there was a legal requirement, and purportedly all the election officials honored that, of having video surveillance. And the reason that we think that's important is because for a challenger, for one of the parties to an election to have the kind of transparency we think elections in Michigan certainly requires elections to have that surveillance, to have the opportunity for a challenger to see that video is what we've requested, in addition to having challengers present. And this, Your Honor, goes to the theme of the whole complaint that we have filed, is just to have transparency, just to be able to have challengers do what Michigan law says, observe the casting of ballots and the counting process.
So I understand that you believe the casting of ballots includes the drop boxes and being able to, almost as if it were a drug deal, follow the chain of custody. Okay, I understand. What else, other than, is there something? The parties don't seem to disagree. Well, maybe they do. Ms. Meingast, do you have knowledge of drop boxes that were created post-October 1?
We do not. The Secretary of State of the Bureau of Elections does not maintain or possess information about when a particular drop box was installed by a jurisdiction. So we wouldn't know whether it existed before October 1st or after October 1st necessarily.
Okay, all right. Please continue, Mr. Hearn.
Your Honor, again, I come back to my central point, and I have nothing further to really add to that. Is just the request that we have is that the challengers be able to access the process, be present in the processing of the ballots as provided in Michigan statute. And that includes, obviously, in the counting boards to be meaningfully available to observe the process. And then what we've mentioned on the drop boxes is that they would have the ability to review the video of that drop box as required, as the video was required by Michigan statute.
I'm going to assume and presume that the plaintiff's motives in filing this suit are as they are stated, to maintain the integrity of elections. I'm similarly presuming that the respondents and the proposed intervener / amici shared those same values. The issue in front of me is whether or not I would issue extraordinary and extensive relief based upon the record before me. The record before me at best is an assertion that the Secretary of State has direct authority over the individual precincts and polling places, the counting process, the transport of all AV ballots, the observation process during the counting of those ballots. It is, and that's a legal assertion. Factually, there is a claim that there has not been an opportunity to observe videotapes of certain ballot drop boxes that were created after October 1 with no note as to where they are, who created them, nor a statutory assertion that it was the duty of the Secretary of State to maintain a listing of those drop boxes so that she could actually order that the videotapes be presented if there is a legal right to do so. There is an allegation, a verified allegation by the named individual plaintiff in this case, that he, a qualified elector and credentialized poll watcher or poll official in Roscommon County, was at some point in time removed from the counting process. The circumstances unknown. There is an affidavit that an individual, I'm told a lawyer and a member of the bar, but no doubt a qualified elector of the state of Michigan, was approached by another human being who was purported to be a poll worker. And that human being told her that someone else told that poll worker to alter a date of receipt of a ballot from the day after the election to the day before the election, and that this occurred on November 4th. The request for relief, as I understand it, is going to be denied in a written order, which will not come out today, but an order which will indicate that the bases for denial are these. First, that the Secretary of State, as the supervisor of elections, provides direction to the local officials as to how they can comply with the laws of the state of Michigan. She has issued such directives particularly one in a case before me, which the number of which I will list later, which indicated that meaningful access and an outline of each of the obligations and opportunities and responsibilities of poll watchers was elucidated, and that she has told the local elected officials to give people that access. Access to videotapes was not a part of the access that was addressed there because they were dealing with active polling places. I will acknowledge that. In this instance, where the issue is the day-to-day conduct of a vote count, the individuals who bear that responsibility, absent the Secretary of State removing them from their responsibility because of misfeasance or malfeasance, lies with the local election officials. So the relief that is being requested in substantial part is completely unavailable through the Secretary of State. Additionally, even if this relief were available, as opposed to when this suit was announced yesterday morning and the count was beginning, it was filed at 4 o'clock, at which point the count had largely proceeded, I am told. But as of this point, the essence of the count is completed, and the relief requested, other than the relief to observe the videotapes, is completely unavailable. The court would finally find that as to the one issue for which relief is arguably available, that on this factual record, I have no basis to find that there's a substantial likelihood of success on the merits as relates to this defendant. Nor am I convinced that there is a clear legal duty on the part of anyone who is properly before this court to manage this issue. I will endeavor to get an order out no later than tomorrow afternoon, but I have both an afternoon Court of Appeals case call and a full case call tomorrow morning. With that, I would thank you all for your presentations and would adjourn this matter where I believe everyone here at their best seeks to have a full and fair election process. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.